If there's one city that embodies the aspiration for peace and the rule of law, it's The Hague. From the Peace Palace, home of the International Court of Justice, to the International Criminal Court and other institutions dedicated to international law, the city stands as a monument to a system designed to prevent us from turning on one another. A system that today appears badly eroded, embattled, and increasingly fragile. In the face of relentless militarism, can international law stop wars from erupting? And once they've begun, can these elaborate systems bring fighting to an end? And what is the hope or the scope for justice once the bombs have stopped falling? International law is often seen as humanity's shield, a collective promise to protect the most vulnerable and uphold justice across borders. But if you've been following the news, you might be asking, if these laws matter so much, why are they broken again and again?
When you bomb civilians, when you attack a nuclear power plant, you are committing war crimes.
Starving civilians as a method of warfare is a war crime.
Some of the recent wars and conflict in Africa, they have been crying out for investigation for alleged war crimes.
Right now, there is a crisis in world order and the rule of law. And for those of us working in the field, it's deeply frustrating and honestly, sometimes incredibly challenging.
Melanie O'Brien is a professor of international law and former president of the International Association of Genocide Scholars.
International law quietly regulates things that we generally take for granted, like sending mail overseas or flying between countries. But for many people, international law only comes up in the news when something has gone terribly wrong. It's usually in the context of extreme cases of serious violations of the laws of war.
Some Israeli soldiers have been posting content online showing Palestinian detainees, which legal experts say could be in breach of international law.
Once you start looking at international law through a political lens, the fact that it has such a mixed record makes a lot more sense. We start to understand why sometimes it works, but often it falls short.
Phil Clark is a political scientist who specialises in conflict and post-conflict issues.
The law is highly selective, from which suspects are pursued for prosecution through to which crimes are prioritised or ignored. Political considerations shape all of that. There's sometimes this belief that law stands above politics, that it's this last refuge of civility in a chaotic world. There's this myth of a neutral legal arbiter above the fray, but the truth is, international law isn't some straightforward solution to conflict. It's deeply political and sometimes makes conflicts even harder to resolve. I think understanding that is key to using it more effectively.
If you want to understand how today's legal system works, you have to look at how it was built. After World War II, atrocities like the Holocaust and Hiroshima prompted the creation of international institutions that were marked by double standards from the beginning.
There was this absolute determination to create systems that would prevent the horrors of the Second World War and the Holocaust from ever happening again. But secondly, there was also this sense of Western liberal triumphalism, this belief that the Allied powers weren't just military victors, but they were also moral victors.
This draft of mankind's deepest hopes already a historic document, perhaps the Magna Carta of peace-loving humanity itself.
Many institutions created at that time were shaped by this very particular Western liberal vision. And it was a vision that very conveniently excluded the crimes of colonialism. Colonialism was happening simultaneously to all of this, often perpetrated by the same powers. These were the same states that were behind the creation of the United Nations, the Genocide Convention, the UN Declaration of Human Rights. In many respects, they were doing that to shore up their own political and legal superiority. So there's a lie at the heart of that period that means that everything that has flowed from them has been flawed as a result.
At the heart of all these legal frameworks are a set of fundamental definitions. They are the building blocks that determine when, how, and even whether the rules can be applied. The core crimes identified under international criminal law are: a crime of aggression is when a country's leaders illegally start a war. War crimes are serious violations during war, like attacking civilians or mistreating prisoners. Crimes against humanity involve widespread or systematic attacks on civilians, and genocide, the crime of crimes, is the intentional effort to destroy all or part of a group based on race, religion, ethnicity, or nationality. The purpose of this level of clarity is to make crimes easier to identify and name, but in practice it doesn't always work that way. In the case of genocide, clarity carries consequences. Once an atrocity has been officially recognised as a genocide, the Genocide Convention is triggered, creating a legal obligation for states to act, raising the stakes for the international community as a whole.
That's one of the reasons why that word is so loaded. And this clearly played out in the Rwandan case in 1993 and 1994.
Whether or not what is happening could be genocide.
Well, as I think you know, the use of the term genocide has a very precise legal meaning.
So many people say that there is genocide underway or something that strongly resembles it. Why wouldn't this convention be?
Well, I think, as you know, this becomes a legal definitional thing, unfortunately.
Whether we get involved in any of the world's ethnic conflicts, in the end must depend on the cumulative weight of the American interests at stake.
The reason he was prevaricating on that issue at the time was because he didn't want to commit the US to having to legally intervene under the Genocide Convention.
In 1994, around 800,000 people were killed in Rwanda in just 100 days. This wasn't random violence, it was a planned campaign perpetuated mostly by Hutus against the Tutsi ethnic group. Political leaders and extremist media fanned the divisions, while the world largely stood by, sending UN peacekeepers who lacked a mandate to properly intervene.
That was the first weakness, sending a peacekeeping force without a mandate to actually keep peace.
I'm talking to Jean-Marie Kamatali, Professor of Law and former Dean of the Law School at the University of Rwanda.
Thinking was that their presence will act as a deterrent, that just being there will hold more authority, but the genocidaires were not afraid.
We have tried to talk to both sides. Every day we do it, they just don't seem to be listening.
And the peacekeepers couldn't push back.
This remains a fundamental weakness of UN peacekeeping missions. Under the principle of neutrality, they can only operate with the host state's consent. But also their mandates almost never allow them to use force or to engage militarily. So in practice, they're often limited in terms of standing as a buffer between warring parties and civilians.
Another factor, there were few journalists on the ground in Rwanda, so reporting was minimal. And with little international coverage, there was no major public outcry. And without that kind of pressure, governments are unlikely to step in or to risk their own personnel.
In these conditions, ensuring safety and survival became the task of ordinary people. Jean-Marie, a young lawyer at the time, barely escaped, and 10 years later he joined an inquiry with scholars, UN officials and diplomats, all asking the same question: what went wrong?
General Dallaire was there. He told us before the genocide broke out, he had intelligence. It was being planned. He sent a fax warning the UN. That warning kept getting pushed up along the chain of command. Eventually, Secretary General Boutros Ghali took it to the Security Council, and that's where things really broke down. The Security Council, the very body meant to protect international peace, failed. Why? Because it was acting in the interest of its most powerful members. US interest, French interest, not Rwandan lives. For Tutsi in Rwanda who looked up the UN flag and believed it represented the world, that was a betrayal.
After failing to stop the genocide, the world faced a grim question. Did the rule of law still matter? In Rwanda, the scale of the horror was immense. Around 120,000 people were arrested for their role in the genocide. The first steps towards accountability came in 1994 with the establishment of the International Criminal Tribunal for Rwanda, a UN court based in Arusha, Tanzania, established to prosecute individual key organisers and leaders.
Generally, there's rarely much domestic justice after an armed conflict or atrocity crimes. That's often because a country's infrastructure collapses, including its government and legal systems. In cases like genocide, intellectuals, including judges and lawyers, are often targeted in that process. But another reason is political. Regimes often stay in power and, quite frankly, they don't want to hold themselves accountable. With the UN International Criminal Tribunal for Rwanda, the focus was on prosecuting those most responsible, which usually meant the leaders. But personally, I don't think that label should only apply to those at the top. You can be low-ranking and still deeply responsible for atrocity crimes.
Many local people in Rwanda, when I asked them about the UN tribunal, which was based quite a long way away in Tanzania, would say something along the lines of, we don't think that's real justice because those suspects are being prosecuted over there, whereas real justice is facing us here in the community.
It raised a crucial question. Who justice is? Who are we trying to protect? Who are we trying to heal? Because if justice feels foreign, disconnected, or elitist, then it doesn't truly work as justice. So Rwanda had to find its own way. The national courts initially focused on trying elite, but made a point of holding trial within the country. Even so, the system was quickly overwhelmed. More than 100,000 people were in prison. The court had been destroyed. There were only about 30 lawyers in the country. The government was stuck between the need to show legitimacy by upholding the rule of law and the reality of a collapsed legal system.
One solution was gacaca, a traditional community justice system once used for minor disputes, now adapted for something far larger, with communities holding local trials in open-air meetings instead of relying on slow, top-down courts. It wasn't perfect, but it got people talking and brought accountability out of distant courtrooms and into the very villages where the violence had happened.
In the years that followed, the justice system was so overwhelmed, many of these men would be dealt with by village courts or gacachas.
In a classic gacacha hearing, the suspect would come in front of the entire community, which could be 200 or 300 community members. And the suspects would be confronted with the evidence to support the accusations against them. And that evidence had usually been given by local people. The task then fell to the gacacha judges. These were everyday people elected by their local communities. And it was up to those community judges to determine the guilt or the innocence of a particular suspect. Everyday people were encouraged not just to give evidence, but also to talk about the psychological impact of the genocide on them. And that's a key feature of gacacha. It wasn't only about criminal cases, it was also about dialogue.
Villages sat together and discussed what happened, who did what, who witnessed it, who was involved. Victim could speak, accused individual could explain or defend themselves. So truth emerged through dialogue. Was it perfect? No. Gacacha was amended 3 times, but over time, it grew into a unique system that combined prosecution, truth, reconciliation, and repair all in one.
To see gacacha's impact, consider this. The ICTR spent over $2 billion to try 93 people in 21 years, while around 12,000 gacacha courts handled nearly 2 million cases between 2005 and 2012. No other country has ever tried so many suspects for such massive crimes, and without gacacha, Rwanda's justice system would likely still be buried under a backlog.
Rwanda is in a much healthier place than most post-genocide societies today because people have really talked about all of the different dimensions of the genocide. In contrast, my colleagues who are working on the Balkans describe deep denial, especially around the Srebrenica genocide in 1995. The Balkans got a UN tribunal as well, the ICTY, but they didn't get much else.
Both the International Criminal Tribunal for Rwanda and the Tribunal for the former Yugoslavia set important legal precedents. They also exposed a fundamental problem. It wasn't feasible to set up a new court for every atrocity. Justice needed a permanent home. Which is how we ended up with this, the International Criminal Court in The Hague. Established in 2002, the ICC became the world's first permanent court explicitly mandated to prosecute individuals for war crimes, crimes against humanity, and genocide.
The primary motivation behind creating the ICC was the idea that it made better political and economic sense to create one permanent body that could handle cases globally. A second motivation was the desire to create something universal. There was this concern that ad hoc tribunals, ad hoc courts were being set up for some regions and not others. A third motivation was the idea of deterrence, that the court should have this goal of preventing genocide, crimes against humanity and war crimes by making it clear that absolutely no one in Myanmar, Darfur, anywhere could claim impunity just because there wasn't a tribunal that was set up for their particular country.
Jurisdiction is a big part of how the ICC works. Most of the time, the ICC prosecutor can only investigate crimes that happen in countries that have become party to the Rome Statute, the 1998 treaty that created the ICC and sets out what it can and can't do. As of January 2026, 125 countries have officially joined the Rome Statute, while around 68 UN member states, including major powers like the United States, China, Russia and India, have not.
3 out of the 5 permanent members of the UN Security Council aren't even subject to the ICC's jurisdiction. And that highlights a long-standing criticism of the ICC, that the court ultimately serves the powerful and it targets the weak. So if the goal was to have a global court applying equal standards, it certainly hasn't played out that way. And that's why the 2024 arrest warrants for 2 senior Israeli officials, Benjamin Netanyahu, the Prime Minister of Israel, and Yoav Gallant, the former Minister of Defense of Israel, are really historic.
That I have reasonable grounds to believe Benjamin Netanyahu and Minister of Defense Yoav Gallant bear criminal responsibility.
Because it's the first time that the ICC has gone after actors who are aligned with Western powers. The US even passed laws to block ICC cooperation, and they sanctioned anyone who would help the ICC investigate.
He issued yesterday these sanctions on this scandalous and corrupt organization, the ICC.
So you could see the US using its power to constrain what the ICC could or couldn't do.
Even today, as conflicts evolve, states must justify their use of force. This is the essence of jus ad bellum, the right to go to war, the rule book in the UN Charter that asks, is this war lawful? There are 3 legal bases: consent, when one state invites another to assist, UN Security Council authorization, and self-defense.
States often justify force as self-defense, but under international law, this claim has to meet 2 criteria: necessity and proportionality. Necessity means all non-violent options, such as diplomacy or sanction, must be tried and exhausted before force is used. Proportionality requires that the response match the threat. In Gaza, Israel's response to the October 7 attacks, where about 1,200 people were killed, has resulted in over 70,000 deaths, more than 171,000 injuries, and widespread infrastructure destruction. That level of force is grossly disproportionate.
All of this is ill-defined and nebulous, and it constitutes basically a site of battle and contestation.
Nora Erekat is a legal scholar and human rights attorney.
An IHL basically regulates a legitimate war, and we should distinguish that from an illegitimate form of warfare, one of which is genocide.
Genocide is never a legitimate form of warfare because it doesn't just violate fundamental international laws, but deliberately targets civilian populations for annihilation, rather than achieve legitimate military objectives. If jus ad bellum asks, can this war even happen? Then jus in bello asks, how should it be fought? The 1977 additional protocols to the Geneva Conventions put that principle into practice, with a focus on protecting civilians and limiting unnecessary suffering, no matter who is fighting.
It's not until 1977, with the additional protocols, that you get an explicit definition of who is a civilian and how they must be protected. It's important to highlight that the US and Israel are outstanding objectors to the additional protocols. They never agree to them.
Almost all UN members have signed these additional protocols, but some countries, like the US, India, Israel, Iran, and Pakistan, haven't. They worry the rules could limit their military choices, affect their independence, or give rights to armed groups they don't control. These laws are extensive, but are only ever meaningful if they're enforced. That's where the International Court of Justice, the ICJ, comes into play. Unlike the ICC, which prosecutes individuals, the ICJ settles disputes between countries and clarifies how international law, including the laws of war, should be applied. Right now, the court is busy with 4 active cases under the Genocide Convention being pursued. It shows that more and more countries are turning to the ICJ to seek accountability. But there's a catch. The ICJ relies on the UN Security Council to enforce its rulings, a reliance that remains a fundamental obstacle.
The Security Council is comprised of 15 members. 10 of them are rotating member states that have 2-year terms, and then 5 of them are the permanent 5 members: the United States, France, Britain, China, and Russia. And those 5 can exercise a veto that overrides the will of all other states.
It's important to remember the problem isn't always a lack of law. It's often the lack of implementation. Sometimes the systems exist, but states simply choose not to enforce them for political reasons.
The US has issued something like 49 Security Council vetoes in order to protect Israel from international accountability. The second highest recipient of such protection from the United States in the Security Council was apartheid South Africa.
For 30 years, successive South African governments have been condemned in the United Nations and saved by Western vetoes from meaningful pressure.
And it's not just the United States. China uses this, Russia uses this, France uses this, Britain uses this. This has accompanied the structure of the United Nations since it was established in 1945. This is not new. What the current moment makes clear is now that it's undeniable.
14 members of the Security Council voting for a ceasefire in Gaza.
Those against.
But it's blocked by 1. The United States, this, its 6th veto on Gaza in almost 2 years.
And it's one that's also created a chasm between the global north and the global south.
The ambassador of Algeria repeatedly apologized to the people of Gaza.
Forgive us because this council could not save your children.
Which is understanding that they are very much subject to an ongoing, unjust international legal system that has been set up by the strong to benefit the strong and to advance their interests.
But it's not just about outside forces. Local authorities also matter. And when they can't fully use the legal tools available, opportunities for justice are often lost.
Think of the International Court of Justice 2004 advisory opinion on the route of the wall. We get the explicit rejection of Israel's argument that it has the right to use self-defense or military force in the West Bank and Gaza. The Palestinian official leadership could have used that finding to basically run a diplomatic marathon and demand that all states, this be their obligation, but they don't. And it's based on the Palestinian official leadership's undying faith and conviction that the only way to achieve Palestinian self-determination is if the US delivers it to them. And they do not want to lose favor with the United States. Other states also fear US retribution and so act cautiously. This is a matter of politics. This is a matter of power. Law does not self-actualize. It has to be implemented, and it's implemented by states. The law can be used in order to strengthen the position of these states, but it won't manifest on its own.
When it comes to genocide, one thing is clear. It doesn't need a legal label to be real. Since the 1948 Genocide Convention, only 3 cases have been officially recognised: Cambodia, Rwanda, and Srebrenica. Yet many communities have endured structural violence without official designation. Legal definitions matter. They shape prosecutions and set international norms. But the law moves slowly, especially since politics often determines its pace. What matters most is recognising violence early and taking action to stop it, and to not allow debates over what to call it delay or derail action.
One of the quickest things to do is to see this and then to say, okay, obviously international law doesn't work, it's trash, it just protects the strong. Yes, the law is subject to a structure of power, but power has been a variable. When power is organized, the law as a framework can be used to advance emancipatory causes.
In the end, it really comes down to politics and international relations, how the laws are applied or ignored. The law itself remains. It adapts, it changes, it builds on what came before. But like any legal system, it only works if states and individuals are held accountable when they violate it.